Background for enactment of Geneva Conventions Act 1960. Introduction. The Indian Parliament passed the Geneva Conventions Act 1960 under Article 253 of the Constitution of India, read with entries 13 and 14 of the Union list in the 7th schedule based on Geneva Conventions of 1949. This act provides the punishment for grave breaches of the Geneva Conventions 1949. It regulates legal proceedings with respect to protected persons, namely prisoners of war and internees. Apart from that, this act also prohibits misuse of Red Cross and other protected emblem under the Geneva Conventions. In spite of having several democratic laws, India has failed to punish the violations of the human rights in the Northeast India and in Jammu and Kashmir. Historical background. It is hardly possible to find documentary evidence of when and where the first legal rules of a humanitarian nature emerged. It is therefore pertinent to search for and identify the roots of the principles of international humanitarian law hereinafter IHL in all great civilizations of the world. It must be noted, however, that since the Indian civilization is no exception with regard to the general gap between precepts and practice, the emphasis will be placed on the precepts, if not on aberrations in practice. Ancient India up to 711 AD. In the early Vedic period, when Indian society was organized in tribal communities, war between communities was normal, with no halberd. Yet in many parts of India, the process of war was divided into 4 stages. Number 1, seizure of the enemy's cattle. Number 2, mobilization for invasion. Number 3, actual fighting. Number 4, victory. The seizure of cattle was advance warning of an attack and gave civilians and non-combatants time to seek shelter. Many ancient texts such as the Ramayana, the Mahabharata, the Agni Purana, and the Manusmriti embody a number of ethical precepts that emerge in ancient India. These precepts may be categorized according to 4 principal aspects of armed conflict as we identify them today. Number 1, methods of warfare. Number 2, means and weapons of war. Number 3, treatments of persons whose they combat, that is, those who as wounded or as prisoners have been placed out of action. 4, treatment of civilians. In ancient India, weapons like arrows, swords, hatchet, and axes were used. While the use of arrows with poison tips in war was perhaps permissible in the Vedic times, Code of Manu forbade the use of poison and poisoned tips in war. When the king fights with his foe in battle, let him not strike with weapons concealed in wood, not with such as one barbed, poisoned, or the points of which are blazing with fire. Buddhayana also prohibited the use of barbed or poisoned weapons in war. Remarkably, the prohibition of the use of poison on the Code of Manu also entered into codes of ancient Greeks and Romans, as well as that of medieval writers. The prohibition of killing those soldiers who had lost their horses, charioteers, or arms or who had surrendered is undoubtedly a major contribution of Hindu jurisprudence to the humanization of warfare. Apastamba notes, the Aryans forbid the slaughter of those who have laid down their arms, of those who beg for mercy with flying hair or joined hands, and of fugitives. To the same effect is Buddhayana's injunction, let him not fight with those who are in fear, intoxication, insane out of their minds, not with those who have lost their armor, not with women, infants, aged men, and the Brahmins. Gautama also instructs that excepting those who have lost their horses, charioteers, or arms, those who join their hands in supplication, those who flee with flying ears, those who sit down with averted faces, those who have climbed in fight on eminences of the trees, messengers, and those who declare themselves to be Brahmins. There were copious rules relating to the treatment of persons who were not directly involved in the war or who were captured as prisoners of war. Enemy non-combatants such as charioteers, mahouts, the elephant drivers, war musician or priest should not be fought with. A panic-stricken foe or an enemy on the run should not be followed in hot pursuit. Guards at the gates should not be killed. A weak or wounded man or one who has no son should not be killed. He who surrendered or was defeated shouldn't be killed, but captured as a prisoner and treated with dignity. A wounded prisoner should either be sent home or should have his wounds medically treated. The ancient text lay great emphasis on the protection of the civilians and the civilians' objects from the adverse impact of warfare. A peaceful citizen walking along a road or engaged in eating or who has hidden himself, an old civilian found near the scene of battle should not be harmed. Fruits, flower gardens, temples, and other places of public worship should be left unmolested. Medieval India from 711 to 1600 AD. The Hindus and Muslim versions of the just war doctrine were interpreted in a partisan way to permit, may even mandate, total elimination of non-believer. Invaders such as Mahmud of Ghazni, Muhammad of Ghor, Nadir Shah of Persia, and Timur of Samarkand invaded India mainly to plunder her riches, and therefore their military campaigns were marked by senseless pillaging, looting, destruction, and slaughter. Yet their history also records dazzling instances of chivalry from the state practice of the Ranas of Chittor in Rajasthan. Nagendra Singh cites some examples of the release of prisoners of war. In 1437 AD, Maharana Kumbha of Chittor defeated Sultan Muhammad Khilji and brought him captive to the Chittor. Khilji remained a prisoner for 6 months. Thereafter, he was set free with ransom. Again in 1526 AD, when Ibrahim Lodi, Sultan of Delhi, was defeated by Raja Ram Chand and made prisoner. The Raja honored him by seating him on the throne. Another well-known classic example was mentioned by Nagendra Singh of the conduct of the young Mughal Emperor Humayun soon after the historic Battle of Panipat in 1526. Sultan Ibrahim Lodi and Bikramji, the ruler of Gwalior, were killed in the battle. The wives and children of the Raja of Gwalior had been left in Agra fort, and the Mughal army captured them. Hearing of this, Prince Humayun intervened and treated them with courtesy and protected them from their captors. Some treaties concluded at the end of a war contained provisions relating to the repatriation of prisoners of war. Nagendra Singh cites a treaty between Sultanate of Bahmani and the Vijayanagar Empire in the south. From that time onwards, it has been the general custom of the Deccan to spare the lives of prisoners in war and not to shed blood of enemies' unarmed subjects. Although it is doubtful if such was the general custom in the Deccan, following the treaty represents an illustration, albeit rare, of the moral authority of humanitarian law amidst the clash of arms. Colonial era from 1498 to 1945. The European colonizers refused to apply to Asia and its princes what little international law they had developed in Europe. Indeed, they argued that the rules of international law applies only in Europe. All wars throughout human history have violated the humanitarian law precepts, but colonialism was founded literally on the bloods of Asians and Africans. Colonial history was replete with instances of wanton killings, plundering, looting, destruction, and devastation, displaying unparalleled cruelty and impunity. In its struggle for independence, India experienced several such inhuman acts of repression, including Jallianwala Bagh massacre of 1919. Another instance of the colonial administration's wanton use of force and inhuman attitude was in 1857 uprising, and the British response to it revealed extraordinary depths of inhumanity. The last Mughal emperor, Bahadur Shah Jafar, was taken prisoner and deported for life to Rangoon. His sons and grandsons were killed instantly by their British captors after they were taken prisoners on an unproved charge of murdering Englishmen. The standard of compliance by the Indian rulers of the colonial era with humanitarian laws was, by and large, better than that of British, although there were also some rulers who recognized no limits to the use of force, the maltreatment of subjugated people, or the besieging and plundering of cities. A few powerful rulers were known for exemplary conduct in their treatment of their enemies and the civilian population. Krishnadeva Raya of Vijayanagar, in a war with King Gajapati Prataprudra of Orissa in 1514, captured the latter's fortress of Udaygiri and took his uncle and aunt as prisoners of war, but treated them with due honor. Chhatrapati Shivaji, the most powerful of the Marathas, in the early 17th century, respected women, mosques, and non-combatants, did not permit the slaughter of human beings after battle, and released with honor the captured enemy officers and men. modern era since 1947. Article 51 of the Constitution of India 1950 enjoins the state to endeavor, number 1, promote international peace and security, number 2, maintain just and honorable relations between nations, number 3, foster respect for international law and treaty obligation in the dealings of organized people with one another. Article 253 of the Constitution empowers the Indian Parliament to enact any law in order to implement any treaty or agreement to which India is a party, or even any decision of an international conference, notwithstanding anything contained in the Constitution in respect of distribution of legislative competence between Parliament and state legislatures. India became party to the 1949 Geneva Conventions for Protection of War Victims in 1950, but it has not become party to the 1977 additional protocols and not yet incorporated them into its statute book through the Geneva Conventions Act 1960. The statement of objects and reasons made by the government while introducing the bill for this enactment explained that the enactment was required because it was expected of India as a party to the conventions to provide for, number 1, punishment for grave breaches referred to in Article 50 of the First Geneva Conventions and equivalent articles of succeeding conventions. Number 2, conferment of jurisdiction on our courts to try offences under these conventions, even when committed by foreigners outside India. Next, extension of the protection given under the existing law to the emblem of the Red Cross and to the other two emblems, namely the red crescent on a white ground and the red lion and sun on a white ground. Next, procedural matters relating to legal representation, appeal, etc. Conclusion. The basic principles of international humanitarian law are an intrinsic a part of Indian heritage. They have at times been deemed but never diminished as central code of conduct to it, and are found intermingled with the ethos of each passing historical era. India, as the largest democracy in the world, is rightly expected to live up to these principles. The Indian legal and institutional framework, which primarily is based on respect for fundamental rights, is extremely conducive, sensitive, and responsive to the implementation of the principles of international humanitarian law. Indeed, the Indian laws, such as the 1960 Geneva Conventions Act, needs to be brought at par with this general culture and constitutional counter of the Indian polity.